Says we're live. I'm going to go listen to it on the Facebook to see if indeed that is true. Then I'll bring my guest up. Yep, got the wrong speaker. Hold on, hold on. Don't panic, everybody. I know the right buttons to push. There we go. And yep, there we go. It all sounds good now. It's of, by, and for the people. These are conversations centered around the American experiment and headlines. Um, and it's with my friends Eric Buchanan and Matthew Durham. Let me pull that off the screen. I'll let these guys tell a little bit about what they do and who they are as briefly as possible. Then we're going to jump into some Supreme Court decisions. We may wander off into some white privilege. We may wander off into some other areas. You never know what the conversation is going to give you. The challenge that Eric Buchanan has and Matthew Durham to a degree is to keep me in the rails. And you'll notice him several times nod his head and be very patient. And then he very professionally, like an attorney, pulls it right back to center to ignore Clint. And then you'll hear him. Here's when you know this. It's coming up. Air's coming up in 3, 2, 1. You ready? Here's when you know he's doing it, though, is when he goes, "So, Matthew, tell me what you think." That's his cue for getting me off the snide. What's up, Eric Buchanan?
Hey, Clint, how are you? Good to see you today. Happy day between the day we voted for independence and the day we signed the Declaration of Independence.
And, hey, England, have fun at work tomorrow. That's what I'd like to say. Have fun at your job while us Americans are taking off.
There you go. Have fun at work, you British.
That's right. Tell everybody who you are and what you do. And let's talk about some Supreme Court decisions and see where those conversations take us, sir.
So, hi, everybody. My name is Eric Buchanan. I'm a disability insurance attorney in Chattanooga, Tennessee. My law firm, Eric Buchanan Associates, helps people all over the United States who've been denied long-term disability, private disability, individual insurance. They call it IDI or just DI, disability insurance. If you buy a policy through work or you get it from an insurance salesman, we can help you if the insurance company is giving you a runaround, won't give you a straight answer, won't pay the benefits you deserve. In addition to disability insurance, we help people with life insurance, long-term care insurance, and health insurance. We help people all over the United States. We can work with local attorneys in states where we're not licensed. We have a network of attorneys that we already work with. We're located in Chattanooga, Tennessee, but we can work just about anywhere. So find us on the World Wide Web at buchanandisability.com. Our number is 877-634-2506. Very briefly about me. Before I became a disability attorney, I went to law school at Washington and Lee. I paid a special attention to constitutional law, enjoyed studying that immensely. I actually had a couple different professors refer to me as the voice of the founding fathers in our classroom. Before law school, I was in the Navy for 5.5 years. I flew P-3s at the end of the Cold War. I went to the Virginia Military Institute, where I was a history major and especially loved studying U.S. history.
And just want to say something. Last week on our deep dive we do on Tuesday, Eric gave me a compliment, said it sounded like Thomas Jefferson a little bit as a founding father, minus my opinions on slavery, of course. But everything else, I sounded pretty good like a founding father, which I thought was a pretty good compliment.
Yep, there you go.
Yeah. All right,
the voice of Thomas Jefferson right here.
Matthew Durham's coming up in 3, 2, 1. What's up, Matthew Durham? How you doing, buddy?
I'm doing pretty well. How are you guys?
I don't know, dude. You got a constitutionalist right here. You got the voice of Thomas Jefferson minus all of the bad crap. You got some shoes to fill there, buddy. You got that's a tough act to follow.
Yeah, I'm not going to hold my breath on that one.
I got it right one time last week. All right, Matthew Durham, tell everybody who you are and what you do, and then let's jump into this.
Sure. Hi, everyone. My name is Matthew Durham. I'm a research project manager at the University of Tennessee at Chattanooga, where I received my master's degree in psychology and my undergraduate in philosophy. The project I'm overseeing is looking at how people's worldview and faith changes over time, comparing American and German participants. Before all of that, I worked in cancer research for about 8 years on 250 different research trials, all across the spectrum of different kinds of cancer. And I'm also a suburban homesteader.
I like that. I like it when you send me pictures of your raised gardens or your crops you're pulling in or things you're building. Hey, Eric, we've had some Supreme Court decisions come down the last couple of weeks, and most of them hit, they release 2 or 3 at a time. Is there a particular one you want to start off talking about today, and how do you want to approach the topic? I think one of the biggest ones was affirmative action. That came down last week, but I'll leave it up to you to start us where you want to start us.
Yes, I would love to start with the affirmative action case. That one is probably the one that I think has the most cultural implications. Also, the probably kind of the most interesting stuff that the Supreme Court has talked about. It's not every day the Supreme Court issues a 240-page opinion. This one's got a lot going on. Yeah, let's start with that one.
Okay. Yeah. How do you want to start? Do you want to read what do you want to read, or want people to know to frame the conversation we're about to have?
So let me start with basically what the case was about, and this one's pretty fascinating because it was actually a combination of two cases. So the same group, a group of Asian Americans who wanted to go to Harvard and North Carolina, sued, saying that they had been racially discriminated against because of the race conscious programs that Harvard and North Carolina both used. Those cases were combined when they reached the Supreme Court, and the Supreme Court issued one opinion on both. Footnote: Ketanji Brown Jackson recused herself from anything to do with the Harvard case because she was actually on the board at Harvard and had been involved in the case. So here's the interesting part that I think a lot of people are missing in this conversation. I've seen on the news a whole lot that basically the Supreme Court is throwing out affirmative action.
Right.
I think that's probably 95% true. They've left a little bit of wiggle room for some ways that race can still be used in decision making, but it's a much
which it may need to be,
right.
Yeah.
But the way it could be used is not just as a blanket. You can't use it just as a plus anymore, that kind of stuff. Let's not get too far ahead. Let's be clear about one of the main things that happened in this case. One of the things that happened was that the group of Asian Americans who wanted to be students at these universities actually was able to either prove or at least get the evidence stipulated to that both Harvard and North Carolina's decision-making process to give an extra benefit to people who met certain minority classifications, African Americans, Hispanics, Native American Islanders, a few other categories, excluded Asians. Asians got no bonus. Asians were counted the same as white, or they were counted separately from whites, depending on how it was going through the process. And in fact, under the system used by Harvard and North Carolina, Asians were excluded on a much greater rate. And what it boils down to is the Supreme Court basically agreed that the race-based classifications used by North Carolina and by Harvard excluded more Asians than it should have, and it was effectively racial discrimination against Asians. And that's one reason why I think the case clearly came out the way it did. I think the other reason that the case came out the way it did is this Supreme Court has gotten enough conservatives on it who believe in the Constitution that they were going to decide that whether or not we have a colorblind society is not the question. We should have a colorblind constitution and let society sort itself out. So one of the fascinating thing was Justice Roberts wrote a long opinion. Justice Gorsuch wrote a concurrence. Justice Thomas wrote a really strong concurrence that basically was his victory lap, saying, I've been arguing this the whole time I've been on the Supreme Court. It's time to stop having racial classifications be used even for a benefit, because that in itself is racist. That's basically his argument, and you get into the details why that is true. You had Justice Sotomayor write a very lengthy dissent going through the older cases and arguing that there really is justification under the law for race-based affirmative action because of societal or systemic racism. And she tried to make that justification based on legalities. And then Justice Ketanji Brown Jackson wrote a separate dissent that essentially, if anybody really wants to know what critical race theory and anti-racism arguments look like in an academic setting, she doesn't use the word equity. She doesn't use the word anti-racism. She doesn't use the word critical race theory. But she writes a very long opinion that basically cites to all of the types of papers that are relied on for those arguments, the statistical differences in wealth between white people and black people, the generational benefits of white people over black people in the United States. And if you from an emotional standpoint, it's a compelling argument. It's the stuff that gets people's attention when you go to one of these modern race consciousness classes that talks about here's all the statistical differences. The ultimate thing that I think makes the biggest difference in the way this case came down is the Supreme Court says you can still use race if somebody wants to describe how individually they were affected in their life by race and put that in their essay that they write to their college or university. That would be okay, because that would show how that individual person has been affected. What you can't do is use race as a part of the decision-making process simply because a person's a member of a certain race. That is essentially a form of racism. That is essentially a violation of the Equal Protection Clause. And then it really should be an individual analysis, not based on the membership in a group. And the Justice Sotomayor and Justice Ketanji Brown Jackson are very, very opposed to that in their long dissents, and Justice Kagan agreed with them.
Go ahead. I'm sorry.
I'm going to stop there and let you guys.
Yeah. Well, Matthew, I'll hand it.
There's a lot more to talk about.
Yeah, I'll hand it off to you, Matthew. A couple things, just my big, 30,000 feet looking down on it, and with my just old common Joe hat here is, first of all, I read a little bit of the dissent. It was a long dissent, and I try to read enough to at least speak on stuff when we have these podcasts. And the word lived experience is great, but you can't make law. And you really can't make policy based off 330 million, 50 million lived experiences. In other words, we go back to it. You have to have some sort of norms, standards, boundaries, expectations. And the thing that struck me to this, and it's coming to you, two quick things that's coming to you, Matthew. One is whenever we see, whether it's Roe versus Wade, affirmative action, we see the other side, which I understand, but they're removing rights. And these are constitutional. Well, they were only constitutional. This was only a decision, go back 50, 60 years. And now I've been having these conversations with Eric long enough that goes, sometimes the court makes bad decisions. We do these deep dives every Tuesday, and I've learned our court system over the last 200 or 300 years has made some really bad decisions. And it is possible that another court realizes that and goes back and says, let's keep it closer to the Constitution. It's not that it's not constitutional. It may have been the original decision was unconstitutional. A lived experience for someone who is of color in Maine is going to be way different than it is from Southern Alabama. That's why I think having something on the application can be reflective of those true differences. And the last thing, and I had another point I was going to hand to you, but Matthew, go ahead. I'll hand it to you. I'm sure it'll pop up in my brain. What's your initial takeaways from all of this?
Yeah, that I don't find the argument that it's based on 50, 60 years of court precedent to be by itself sufficient. And precedent certainly is important, as I understand it. But if we applied that same principle, that precedent by itself is sufficient, rather than also and much more importantly looking at what's actually in the Constitution itself, then we would have used that same argument to continually justify slavery, and argue that there was 50, 60 years of precedent within the Constitution at the point of the Civil War.
Before we go too far down that hole, Matthew, Clint, that was a really good question, but let me just clarify. The court addresses that very clearly, and this court didn't overrule any precedent. Period. Full stop. Anybody reporting differently is fucking lying. And I'm sorry I had to use the F word again.
That's
but
2 weeks in a row.
I'm sick and tired of having to deal with this kind of crap. The two cases that the Supreme Court has addressed that are the main cases are it's Regents of University of California v. Bakke versus in 1978. And everybody says, okay, that's a 1978 case that says affirmative action is okay. What Bakke said was that there were 4 justices who said it's okay for colleges, universities, other state actors to use affirmative action to right past historic wrongs, to fix offensive. They weren't calling it systemic racism at the time, but essentially 4 justices said that what the left is now arguing, that you can use affirmative action to fix historic wrongs and give a plus to African Americans because of the way they've been treated in this country, or other minorities for their mistreatment. That was not the majority opinion. That was 4 out of 9. There were 4 justices who basically said the same thing that this new case says, which is you cannot use race in any meaningful way, in any way to give anybody even a plus, because we have a colorblind constitution. Justice, oh my gosh, it's the one guy that went to WNL, and I had it at the tip of my tongue. I just lost it. I remember 1 second. So there was one separate vote. Justice Powell. Sorry, thank you. I was too early in the morning. Justice Powell, who happens to be the only justice who went to law school that I did, voted separately, and he said you cannot use race as a negative. You cannot use race as any kind of a systematic bonus. What you can do once you've considered all the other factors is you can use race as a plus. Now, he didn't address the fact that if you use race as a plus, then it's a minus for somebody else. And so that case basically says, yeah, you can use it as a plus, but only if you use all these other factors and do all that first. But that's actually only one judge's opinion. There were 4 justices that said you can use it as a blanket rule, and there's 4 that said no, you can't use it as a blanket rule. What ended up happening was everybody was trying to interpret this Bakke case that was a plurality opinion, 4-1 and 4, no majority. And they end up kind of saying, well, I guess the closest we can do is we can use it as a plus till the Supreme Court tells us otherwise. But it was not a majority opinion of the Supreme Court saying that that was okay. It was absolutely not. Only one justice said that we could do it that way. And so then we get to the Gunter case, which was in the early 2000s, and that was the one that was Sandra Day O'Connor. And what she says in Gunter is, all right, looking back at what courts have tried to do with Bakke, you can use race as a plus in certain circumstances if you're very careful about it, but that has to have an endpoint. It
she said
cannot
something
last forever.
like 25 years.
And she says that it has to go away. Expect that'll go in 25 years. But she doesn't just say it as a throwaway. They say it like 5 or 6 times throughout the opinion. That one of the issues with any kind of affirmative action plan is it has to be able to fix a specific wrong and have some specific goal in mind to fix that specific wrong. It's not just a blanket right to do
in perpetuity. It's not for him
in perpetuity.
Yeah.
Absolutely not.
Yeah.
And so the people that are arguing that this case, well, this is a rogue Supreme Court that's overturning past precedent. No, absolutely freaking not. This is a Supreme Court that takes this past precedent and very carefully analyzes it and says, okay, 1, we never gave a clear statement on this before, and that needs to be fixed. And that 2, now that we're really sitting down and addressing this and looking in the context of how these universities are actually, in fact, discriminating against Asian Americans, because anytime you use it as a plus, it is a minus for somebody else. We've got to put a stop to this, and we've got to be clear that this was never okay under our constitutional rules. And so the idea that this is overturning some kind of precedent that's a narrative from liberals and people who don't, or progressives in the media who have not read the case carefully or who are not being forthright about what this case says.
Let's go back to Matthew. Matthew, go ahead. You had the floor, sir.
So clarification from Eric, understood. Even if they were right, though, right? So it appears that based upon that clarification, they're wrong on the facts. This is not an overturning of course precedent. Even if it had been, though, you can still use that same rationale and attempt to justify slavery. So from a procedural standpoint, that isn't necessarily the moral position to say, well, it's precedent and therefore, because the Supreme Court has shifted and gone against precedent in the past before in ways that many people living today, most people living today would agree were morally justified and a more accurate interpretation of the plain meaning of the Constitution.
For example, Dred Scott and Plessy versus Ferguson were cases the Supreme Court decided that everybody agrees now are wrong.
Right. So, and 2, I think I've encountered a really helpful way of talking about the whole, we're going to give you a plus and that must mean that somebody else gets a minus. Glenn Loury has made the argument that if we're going to say that one group is underrepresented, by necessity, that must mean that some other group is overrepresented. Which groups? Are you saying that, there certainly is a whole lot of Jewish people, who get into these universities. Are you saying that Jews are overrepresented? Are you saying that Asians are overrepresented? Is that the argument here? Right? There's just too many. That's where it goes. That's where we're going to give a plus to one side, by necessity a minus to the other, because you believe that those racial groups are overrepresented. And it's unfortunately something that I don't think very many people are willing to acknowledge when they push for giving one side a plus. But it's inevitable. There's no way around it.
It goes to that point, though, real quick, Eric, is that, past transgressions warrant future transgressions, right? Because we were this, now it's okay if we're the exact same thing, just on the other side. And I just wrote this down. It is, I think this decision, no, to your plus minus, sometimes in life, your success doesn't mean that I have to fail, but sometimes in life, a plus does equal a minus because there's limited opportunities at these
If
colleges.
there's only so many openings
That's
in
right.
this class at Harvard.
That's exactly right. And so this is a good example of that. And Eric, I said this to Jeff Stiles this past Friday when we were on, when he and I do our podcast. I think this decision, rightly so, hopefully will start putting down pressure on the high schools and the family units, because a lot of the issues that we talk about, the being able to compete at certain levels, whatever that is, those should be addressed as a family unit and the local education where you're going, and through the parental and interactions with the board. And I think this is going to put pressure down and put more of the spotlight down on them, going white, black, Asian, whatever. If there's issues, let's get it together in the communities and the families and the schools, and then you won't have these issues, hopefully, moving into college. That may be a utopian way to look at it. Back to you, Eric, for actually real hard stuff and not just Clint's feelings.
So let me talk a little bit about the court's reasoning, because there's 4 areas they get into, and I think these are fascinating, and they actually overflow into the conversation we need to have about the current cultural fight over this kind of stuff.
Okay.
So the Supreme Court started by reaffirming that the rule that applies whenever a government agency or any covered entity that gets federal funds, essentially, hyper technical. This case applies both the 14th Amendment and Title VI of the Civil Rights Act, which applies to universities like North Carolina. Like Harvard, they get federal funds. North Carolina is a state entity for North Carolina. Harvard gets federal funds, so they are covered under Title VI. But essentially, the analysis is the same. And so the analysis is that if you're going to use race as a differentiator, if you're going to use race as a public policy, that you have to follow strict scrutiny. And strict scrutiny has to meet the law, or a rule or a policy has to meet this extremely high standard to be okay, to be not unconstitutional. And that test is, it has to further a compelling government interest, and that the government must use it as narrowly tailored as necessary. And the Supreme Court then goes into, now, what we've said in the past about racial classifications for hiring and other forms of affirmative action. If you're going to have a race-based program, for it to meet that test, it has to meet 4 things. It has to be measurable. There must be a meaningful connection between the means they employ and the goals they pursue. They must not use race as a negative or a stereotype, and there must be a logical endpoint. That's from all the old Supreme Court cases that actually have addressed this. And that is part of the history of the Supreme Court cases on this issue. And they say that Harvard and North Carolina failed on all 4 tests. And in fact, to pass strict scrutiny for a race-based classification, you have to pass all 4 tests. They didn't pass any of those tests. They failed on all 4 of them.
It wasn't like 3 out of 4. It was 0 out of 4. Yeah.
Yeah. So, and I don't want to get into a ton of detail on all 4 of these. We could if you want, but let me just give an example of the meaningful connection between the means they employ and the goals that they pursue. So to accomplish the goals, according to the Supreme Court, both universities use the same racial classifications, and they put people into 1 of 5 categories: Asian, Native Hawaiian or Pacific Islander, Hispanic, White, African American, and Native American. And so one of the questions that came up at the Supreme Court level was, where do you put somebody from Jordan or Yemen or Egypt? They're counted as white. So those people get no benefit. Who counts as Hispanic? somebody who's been a 6th-generation United States citizen who happens to have Perez for a last name.
Well, I was
Or
going to ask you a question. We've been going on. I hate to interrupt you, but I'm sitting here thinking about it. We live now, the system we live in is so many mixed races now. We
let's slow down there, Clint. Let's
Yeah.
not get that gets
Oh,
hold that thought
oh,
for a second.
okay.
Don't jump ahead.
Yeah.
All right. Let's finish the foreplay here, Clint.
Okay. Yeah. Well, you're going to have to pick up the foreplay, dude. I need to get to the good stuff. What are we doing?
Well, this is the good stuff.
Yeah.
So one of the things they differentiate is by throwing Asians into one category. These universities have put 60% of the world's population into one category by calling them Asian. They don't differentiate between Cambodian Americans and Montagnard Americans and Chinese Americans and Mongolian Americans and anybody basically east of Iran. They're all lumped. So people from Thailand, Japan, and Montagnard tribesmen from the hills of Vietnam are all treated the same. So that's one of the critiques the Supreme Court gives. I mentioned Hispanic, and the Supreme Court basically, goes into, well, who counts as Hispanic and what's the definition? And then there's the classifications are under inclusive because they don't include anything for people from other minorities that might have been persecuted, like Middle Easterners, like Arabs, like Muslims. So they said that they are arbitrary, undefined, and under inclusive. And then the Supreme Court gets into something I think is really compelling. They basically say, you told us before in the Gunter case that that you experts at these universities could do a good job of sorting through this stuff, and you would be able to show us how this worked, and that we should allow you the benefit of the doubt. And the Supreme Court said, basically, we don't trust you anymore because we're looking at what you're actually doing. And they ended up having, like, the Supreme Court put in a chart of how the percentages of Harvard's classes year after year had not changed. And in fact, Harvard admitted that was one of their criteria. When they get done with the first round of admissions and they need to decide who's going to fill out the rest of the class, they pull up this chart that lists where are we in filling up our 11% allotment for African Americans and where are we filling up our X percentage it is for Asian Americans. And so they're not and there's a pile of just a few African Americans left to fill those slots and a big giant stack of Asian Americans to fill in. Guess who doesn't get to be filled in? And so they go through that very specific thing. So yeah, and then you're right. The Supreme Court then talks a little bit about, well, what about some of the other classifications? And like what you're saying, Clint, it gets even worse in real life. What do we know now? How many of us have family members that are mixed race or close friends that are mixed race? How do they count? The Supreme Court did not get into this, but they did in there was some dissents in some older cases that basically said, if we're going to have affirmative action and we need to decide which races qualify and which races don't, is it better to go back and look at the misogyny laws that were used to exclude mixed race marriages in Louisiana in the early 1900s, or do we look at the Nazi anti-misogyny laws that said how much of a percentage of Jewish blood you could have to be counted as Aryan versus Jew? Which of those guidelines would you like to use for affirmative action? That wasn't mentioned in this case, but that's one of the arguments that's been used in the past about, once you start giving people benefits of the doubt based on race, which racist totalitarian regime do you want to use their race classifications to help you write the new laws?
And Matthew, it's coming to you, and we've said this a bunch. And when someone else gets in charge and they define things differently, how is it going to be used differently at that point, right? With affirmative, you know what I mean? I mean, if there's a hammer laying in the room, you better hope you're the guy or the girl that's in charge of the hammer. If not, it could be turned against you. Matthew, do you own any feedback on this one? And before we let Eric take it to a different direction.
Yeah, and then there's two things, and one of these might be going a little bit too far afield, so I'll just field the idea and let you guys respond to that second. But the first one, just quickly, the interracial marriage rate, last I saw, was between 17 and 20% of children are born to interracial couples.
Okay.
Give that 15, 20 years, right? If the trend continues in that direction, assuming that we're not living in a world in which racial tensions are continued to be made worse by the CRT folks who are obsessing over it all the time, and everyone who is doing their bidding in the media, we could be looking, if that trend continues, at the majority of people being mixed race and multiple mixed races given multiple generations, at which point it becomes so messy as to be incomprehensible as far as I'm concerned. The bureaucracy that you would have to build to be able to sort all of that out, and inevitably you'd end up start seeing people advocating for the one drop rule that Eric alluded to. It's untenable. There's no way to do it, and that will only be more the case as time goes on in places like the United States. The second piece, and maybe this is a follow-up for once we get beyond some of the legal stuff, is because the consideration of race as a plus is being removed, this is going to put educators into, frankly, a much easier, much more effective position in terms of designing the curriculum for their courses. Because if you're saying that one of the things that gives you a plus in terms of being meeting the requirements for getting into a program is the happenstance of someone's birth, rather than their developed ability to meet the baseline understanding that you need to take the course, right? You've read the right books, you understand how to do the right math, whatever it may be. The moment that it just becomes about, do you have the necessary foundation to take this course, instead of anything else, teachers can then know exactly how they need to design that course. Right? They have a foundation. They say, okay, you've reached this level of math. You've already learned algebra and geometry. Right now we can get into pre-calculus. Without that definitive line that every student has to meet, and you're not bumping some students up to give additional diversity to your classroom who didn't meet the requirements, now you can correctly set the baseline for your class. And that also means that those students who don't meet that baseline can then shift their attention to other programs where they will meet the baseline. So they're not being pushed into a program where they don't know what's being taught.
They're not set to fail.
Yeah, exactly. If my son doesn't have the right background to take a course, I don't want him in that course, right? He needs to understand the baseline information needed to then progress and be capable in that course.
And real quick though, Matthew, what does that do though, real quick, for your son? That puts pressure on the current school he's in and you as a family unit to make sure that he is prepared.
Absolutely.
That's where I think this inherent pressure, it could be an unintended consequence. I think could be a positive one down the road. I didn't mean to interrupt you.
Absolutely.
I apologize. Yeah.
No, absolutely. It means that I don't send him to the wrong school, right? And I would think that any parent, regardless of their background, would want their kid to go to the school that was best set to meet their kid where their kid is, and then take them further.
And you'll get him the help he needs.
Exactly.
Yeah. If he's deficient in an area, you'll help him.
One of the things that we've seen with this mismatch problem with affirmative action programs at a lot of universities is you'll have groups or students that got a plus, right, from the system getting in, and then they want to take, maybe they want to go into law, or maybe they want to go into science, whatever, some of the sciences, but because they got the plus, they now don't actually meet the minimum requirements for the course in terms of what they understand. So they end up dropping and switching to easier majors. Whereas if they would have gone to another university where that was set at their level of understanding, they could have been incredibly successful and eventually gotten to where they needed to be. But we are creating failure as a consequence.
Well, and two, a lot of people look at this and say, this mainly relates to, and it does, I'm sure, people of color, but also if it goes into a math class, Clint's not going to make the grade. I'm white. And if I have to meet a certain standard, and in Asians, whether it's culture or family, whatever it is, if there's somebody I'm competing against and they happen to be Asian, I'm not going to get that spot either, because if they include me, that means they're lowering the standards. And I'm going to be set up for failure because I'm going to be in a room competing with folks with a base of knowledge that I don't have. And I'm going to be frustrated. And then I leave the system up with two options: pass Clint along anyway, because we need more white people in this class, or Clint can go figure it out and learn and maybe go to a different class till he's ready for the next thing, if that makes sense.
Yeah, I mean, it applies to grade levels too. Like, imagine not having a certain baseline expectation for what you need to know to be in 5th grade.
And that's where we're seeing that already, problems.
Yes.
I think this is a problem that's going to be trickled up, not trickled down.
Absolutely, and it has been. One of the things that I saw when I apologize, I'm kind of dominating here. When I've taken my son to look at different schools, is one of the I would ask them, "What's the failure rate for your grade for middle school or whatever?" And their response is, "Well, we don't have one."
Yeah.
Like, oh,
Hey, your kid can't fail here, buddy. I don't know if that's a good life lesson. I'm not sure.
right?
Eric?
So, question number 3, or test number 3 that a university or other organization that wants to use race-based preferences has to meet is that it must not use race as a negative or a stereotype. We've discussed how they use it as a negative. The Supreme Court talks about basically if you give a plus to African Americans or Hispanics and you only have so many slots in the class, let's say there's, I don't know what Harvard admits, but let's say it's 1,000 students in each class, and if you give 10 extra slots to Hispanics or to African Americans, the way it has worked out, the actual math showed in this case, that meant 10 fewer Asians would get a chance. The Asians who were otherwise equally or higher qualified. So that's the Supreme Court found it was a negative. But then they also said, and you can't use it as a stereotype. And the Supreme Court goes into detail about that the way Harvard and UNC did this was impermissible, pernicious stereotyping. Because what the universities actually argued was that the reason we need to do this is to provide a better academic atmosphere for our students and to have the diversity of differences within the college experience. But then their analysis, as you dig into it, basically says, so diversity means we needed more people of a certain race. The Supreme Court said one of the principal reasons race is treated as a forbidden classification is that it demeans the dignity and worth of a person to be judged by ancestry instead of by their own merit and essential qualities. If the university admits students on the basis of race, it engages in the offensive and demeaning assumption that students of a particular race, because of their race, all think alike.
That's called
So-
racist. We used to have that. That's what the KKK thought. They, because you looked a certain way, then you automatically were less valuable and had all shared the same mindsets, and everybody's the same, and we are then justified in our opinions.
And then the Supreme Court goes on, stereotypes that treat individuals as the product of their race, evaluating their thoughts and efforts, their very worth as citizens, according to a criteria that is barred by the history of the Constitution, can only continue to cause continued hurt and injury, is how the Supreme Court said they need to address this. So when you're saying, basically, that's one of the problems we've always seen morally with affirmative action is, if your claim is you want diversity, but you claim you want diversity of thought, and you want to have some students get to have a chance to meet these people who think a different way, and the way we're going to do that is bring in people based on their race. You're making the racist assumption that all the people in that race think alike. And
I'll be honest with you, Matthew, back to you, man, if you got something to add here. If we want real diversity, and I'm not saying this is a solution, it's just an example. You take an African American that's born in Massachusetts and you put that up against a poor white person born in the Appalachian or from Southern Alabama or Louisiana or whatever, and you put them in the room together, let's say by some chance they all hit the same scores, they're going to be pretty diverse in their background. But if you were to take a snapshot of them and show it to the people that were in charge of this, they would have automatically assumed maybe the opposite, right? They would have assumed, well, this person based off looks has this experience. This person has a different experience. That's not America really anymore as much as it used to be.
The critical race theorist folks like to describe, they like to try to escape this, what they call an essentializing problem. It's where because you share a particular color of skin, that means that you share a basic similarity, a fundamental similarity in terms of how you've experienced racism and racial discrimination within the United States or wherever we're talking about. And that gets to this argument that everyone in fact has the same experience if you're talking about Black people with racial discrimination. That's the argument that the CRT folks make. Of course, when you have someone like Larry Elder, who they've referred to as the black face of white supremacy, who then says, no, that's not my experience. And there's a ton of these people out there. Coleman Hughes, if you're looking for someone on the left, Glenn Lowry, just tons. If I have
Tim Scott,
write down, 50 names. Those people are told that they do not have an authentic experience, right? They're Uncle Tom's or what is it, Oreos or whatever the insulting term of the day may happen to be. And what they're really getting at there is you do not have these people who deviate from what we say is the authentic narrative of racial discrimination, do not see things through the appropriate lens. They've had what's the Marxist term? Internalized oppression. They have internalized the supremacist narrative, the white supremacist narrative, and they have now become its unknowing voice,
basically,
right?
A surrogate, basically, right? Like we're going to carry it around. And this is how you get people like Joy Behar go on The View and start really telling, and this really happened, start telling African-American people that were speaking opposite viewpoints of her, of what they forgot what it's like to be Black in America, basically. That she chastised them for not remembering where they came from. And I'm like, if that was reversed and a conservative had done that, just like if a conservative president had said, if you don't vote for me, you're not Black, all of those things they'd be t-shirts. That would still be crucified for that. Back to your point, though. Yes, that's how you get to the point where if you have a differing view, you're not really part of the race anymore.
Yeah, and it really genuinely is that. If you are not race conscious in the critical race theory sense, then you are not an authentic voice of someone who has experienced racial discrimination, whether you're Native American or Black, whatever it might be. And we used the very helpful example of The Matrix in our discussion on CRT a few weeks ago, you and I, Clint, where these people, the Larry Elders of the world, right? They're inside the racial matrix. They don't know that they are. And the matrix itself speaks through them, just like when one of the agents takes over one of the humans that's inside the matrix in the film. Anyone is a potential can potentially be taken over by an agent, right. and speak the voice of the matrix, whether they want to or not, and they don't know. And the only way to get out of that is to develop this critical consciousness of race. We're going a bit far afield, but ultimately that's how they do it, is that they make the racist argument that everyone of a particular race experiences the same thing in the same way. It's just that some of them don't realize that they do.
Eric, to you, what are the consequences of this? How do you see this playing out in not just colleges? Don't you see this also affecting workplace stuff and everything? I mean, isn't this a bigger decision than we may be thinking about it, or am I overblowing it a little bit? Are they not related?
So we're skipping ahead because there was one more part of the actual decision that I wanted to talk about. I know we're spending a lot of time on this. So hold that question, everybody. I do think this has legs. I think it's going to be harder for big companies to have HR programs that discriminate based on blanket rules that we have to have affirmative action. And there's going to be employment lawyers that are going to use the reasoning from this case to argue that Title VI and Title VII of the Civil Rights Act basically should be using the same rule. But hold on for that, because there's one more point of the 4-part test. The other one is that the Supreme Court says, based on that Grunter case, the one where Sandra Day O'Connor said this should go away in 25 years or so, when they acknowledge sort of that race could be used as a plus, adopting what Justice Powell had put in his one judge opinion in the Bakke case, they said it in the context of but there has to be a specific goal in mind to fix some specific past historic racism that actually applies in this instance. And so there needs to, if you're going to do it, you need to be able to say, and we will have fixed it if we achieve blank.
Right.
And if you don't have, we will fix it if we achieve blank, then you have continued pernicious racism, that you still have race-based admissions that don't have any meaningful goal. So you're continuing to exclude Asians and add pluses to the African Americans and the Hispanics. So there must be an endpoint. And I wanted to, without digging into what the case actually says, I just wanted to compare this to something we talked about in the last few years. Remember when George Floyd was killed and the Black Lives Matter movement was pretty active, and one of the arguments that people got into was they would say Black Lives Matter, and even Bernie Sanders said, "Well, all lives matter." No, you can't say that. Why can't you say that? Because the Black lives are the ones that are hurting right now. And the argument they made was, if you go to a funeral and your friend's dad has passed away, you don't go, "I'm so sorry for all the people that have died." You say, "I'm sorry that your dad died."
Right.
So the Black people said, well, you need to say Black Lives Matter because that's who matters right now. And as that conversation was going on, what you heard from people who started to think about it, maybe asking some questions, if you're allowed to do that. Well, then, if that's the scenario, if we go to the funeral of your dad and I say, "Yeah, I'm sorry your dad died," how long do I have to keep saying that before the next person dies or the next person dies? And I'm allowed to say, "I'm sorry that all people have died," or "I'm sorry that people have to die," or "I'm sorry that your family members died." It's not always just about your dad. If things can go on. At what point can we stop saying Black Lives Matter and say, once again, all lives matter? What is the end point of that? And the Supreme Court does like the legal version of that. And they basically ask the question, at what point will Harvard and North Carolina's plans reach the stated goal of achieving sufficient racial diversity that we no longer have to have a quota system? And basically what the Supreme Court does is they go through the analysis of these plans. They say this is just, according to their own analysis and their own rationale, it's a never-ending race-based quota system. There is no stated goal that will there's no way to finish the task. It's always going to be an ongoing program. And that's the essentially the similar argument that we've heard from the race-based consciousness people over the last few years. You always have to have these programs in place. Maybe if you really pin them down, you might say once all the outcomes are equal on their own and you get the equity of everybody having the same outcomes, then we can stop doing it. But then if it starts to differentiate again, don't you reinstitute the program? Isn't that basically what equity would say? And the Supreme Court says, no, you can't do that in a country governed by a constitution that's supposed to make everyone equal. You cannot have indefinite race-based quotas.
Yeah, I mean, and Matthew, coming to you, the policy stuff, we've talked about this so many times. Government is never, ever, 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 ever going to fix 100% of anything. That's why we have the court systems. All they can do is put the thing in place and say this is the standard. Matthew, I compared it to this on the Jeff Styles podcast. And it's a very clumsy analogy, but I'll kind of let you play off this and what Eric just said. It's almost like when you're super sick, you go to the ER, they put you on big doses of medication immediately. There's a problem, let's fix it. Once you get past that point, they start doing monitoring, and then they say, okay, we can adjust the medications. We can put you on different medications. You can come off the medication. However, if it flares back up, we will adjust and start re-administering the medication. And what I mean by that is, yeah, it may have ran its course, affirmative action. And if we remove it, if something comes up now, that's why you have the court system. We have the social media pressure now and the court systems. Again, it's not what it was 80 years ago. The standard is going to be different. You're not going to get away with the wink, wink, nod, nod as much as you would have 80 years ago. So I don't know if we need to keep giving ourselves the emergency medications when it seems like we should be able to run on our own system now and address things as they come up. And we all can point and go, that is a discretion we should not live with.
And there may be cases where we see a disparity, and we shouldn't care. We shouldn't be concerned, because maybe that disparity is there because people are choosing to go in directions that create it of their own free will. We've talked about it briefly before. There's a massive disparity on the United States cricket team. A racial disparity. It's huge, but it's not there because of racism. It's all people from Southeast Asia, right? India and whatnot. If you go look at the roster of the United States cricket team, right? And it's not because anyone is discriminating against any particular racial group in terms of who is trying out for the U.S. cricket team. You can't make, this is Thomas Sowell's example, you can't make twins born in the same house, raised by the same parents, equal in every way. You're going to have disparate outcomes. Even when you control for nearly everything else that could possibly create equal outcomes, you're going to have different choices made, different skill sets brought to the table by individuals, even in cases where they are genetically identical, raised in the same house, in the same region for the same period of time, going to the same schools. So this dream of equity doesn't even work in principle at the level of people that are in the absolute perfect situation to achieve it. So then the question becomes, why would we attempt to apply it in the much messier arena, the broader arena of racial groups brought up in hugely disparate places, even in the same country? Like, being raised in Nebraska is not the same thing as being raised in Appalachia or Alaska, right? You're going to be exposed to different ideas, skill sets that you're taught, educational opportunities. To demand that there be equity amongst all three of those backgrounds, even without considering any other factor, is crazy.
Yeah. Eric, you want to add something before I drop something in there?
So you asked the question a second ago, Clint, about what the effects of this going forward are going to be. And I think clearly in the government setting, there's going to be some serious questions that are going to start being asked. What are some of the things we normally hear all the time? It's almost like they become accepted in American society that government can have minority-based contracting, where the city or the state or the federal government gives a preference to who's going to fix the roads or who's going to build a government building to a minority-owned business. That might be a problem now. We heard during the COVID pandemic that there was the sort of the medical justice movement that treatments need to be given to people of certain races first. I think if the government tries to do a program like that, I think that's going to run afoul of the reasoning of the Supreme Court in this case. Also was pretty darn stupid if you do that. If you want to give people who are most likely to be sick, give priority to people who are most likely to be sick, but that's not based on race lines, unless it's something like sickle cell anemia, which is based on race lines, and that's fine, but that's actually based on sickle cell anemia, not the color of the skin. So those kind of decisions that any government institution that wants to say, well, we're going to prefer people of this race for a certain reason, that's now subject to this 4-part test and the reasoning of the Supreme Court in this case. I think it's going to make a difference. I think it also makes a difference, like I said a minute ago, I think it's going to bleed over into other areas of private relationships that are governed under federal rules, like fair employment laws, that if a big company says we are trying to hire, this internship is only available to Hispanics, African Americans, and Pacific Islanders, I don't think that's going to fly anymore. I think there's going to be some real problems with that.
Yeah, you brought up cricket, Matthew. And since I'm a big cricket fan, I thought I would just chime in. No idea anything about cricket, but I did play rugby. So here's my question. Here's my my pushback, or just my insertion on this. If a person of color, though, or a white person goes and plays cricket, not Asian, whoever, there's a coach and expectations. And if I'm better than Matthew and Matthew's the player, then I'm not saying there's not nepotism. I'm not saying there's not politics. That goes on everywhere, from the church to business to government to sports. I'm saying I got a better shot of making the team once people see that I'm better than you. And if not, another team will pick me up. That comes to exposure to the sport, right? me and Eric played rugby for years, and we see it more now, but I played football also, and I tried to get a bunch of my buddies who were black to come play rugby, and they were like, I am not playing rugby. If they had to come out and played rugby with me, it would have they would have loved it. They would have kicked butt at it. But isn't it odd? I never hear any of the same people that want affirmative action anywhere else in any sports. And I'm saying it's kind of a silly analogy. I'm taking it to the nth degree, but I don't see anything like, why is it not, population and race not represented in the NBA or the NFL or, hockey? I mean, where is it? Now we hear people talk about the coaching, the ownerships, but why not the players? You know why? Because everybody understands if you can't play at a certain level, you don't get in the door. And that is the part to me that just I'm like, well, if it makes sense there, shouldn't some of that bleed over into common sense in other places too? All right, that was my 2 cents on the cricket thing. There we go.
Is there underrepresentation of transgender athletes on your daughter's softball teams, Clint?
Well, she didn't play softball anymore, but I'm sure there is somehow there's underrepresentation.
So
Yeah,
should there actually be affirmative action to get more of them involved?
I got to be honest. That may be an awkward locker room for whoever is trying to do that from a dad's perspective. I would just go ahead and you would probably be talking about a headline that includes your friend Clint Powell at that point, and I would have to recuse myself from the podcast because I'm going to be the topic of conversation. That's not going to be a happy locker room. All right, back to you two in real life news. Eric, where else do you want to take this? And I want to make sure we give as much time as we have to. And then at some point in time, Matthew had talked about, I guess, some of the aftermath of George Floyd and how that played out at UTC, if I'm not mistaken. And
not
or
so
was
much
that
George Floyd, but specifically this affirmative action decision.
Eric, are we at a place where Matthew can jump in?
Yeah,
on that
that'd be a great time.
Yeah.
Let's just put a pin in this. I think, Clint, if you and I can find time over the next week or two, we can do a deeper dive in the actual decision as sort of a constitutional podcast.
We can take this wherever you want to go right now.
Yeah,
I don't care.
Let's not do it now because
Yeah.
to do a deeper dive into really some more stuff that was said in the opinion, and we've already been going for a good while. Let's hold off on that deeper dive. Let's talk a little bit about the reaction. Matthew wants to talk about UTC. I want to talk about how our president has reacted to it politically for just a brief second when we get to that.
All right, Matthew.
All right, well, I guess I'll start local. So 2 reactions that I have sort of queued up. One is the official reaction from the let's see, this is from
some department at UTC
UT System President Randy Boyd. So this is the big boss. And he sent out an email on Thursday of last week to all of the employees and students, I believe, and staff, basically just saying we're going to be looking into this over the next few coming days and weeks. We're going to get into the details, determine whether it will impact our campuses and institutes. And then it's just mostly boilerplate after that about the value of education and democracy and so on and whatnot. So just kind of we're not sure. We're going to look into this and be assured that we care about education and so on.
Okay.
I can speak both to having read the diversity materials in like the mission and goal sections for UTC, sort of the UT system, UT at Chattanooga, and the College of Arts and Sciences stuff on diversity and inclusion at UTC as well, more specifically. And they all very much tread into the notion of race being a significant factor in diversity, race, gender, and several other things. At the highest level I've seen, they do talk about diversity of perspective, but as you drill down into smaller sort of departments, you lose that and you start seeing more of the focus on specific categories that they care about. And I have also heard through the grapevine that many departments, I don't have documentation to this. This is just how it is applied, irrespective
Throw
of
it out. Quit
down.
being scared, man. Go. I know it. You're trying not to get fired. I don't blame you.
No, I don't have documentation to support this. I've just heard it. And that there is definitely a push to maximize the number of people from underrepresented groups that are hired. The difficulty is one, there's not as many people from those categories to hire, not enough for every university to have the full complement as it is. So you're fighting over a smaller pool of folks by itself, right? If you're looking for the gay, trans, person of color who's a Muslim,
Who's
and
disabled.
disabled and overweight. That's you're shrinking the potential pie of people that you might hire by necessity. So every category you add makes it harder. Not to mention the fact that Tennessee, the UT system, is not able to typically offer as competitive of pay. And a lot of folks from those groups don't want to move to Tennessee because they see it as a more conservative place that's less friendly to their politics. So all of those factors combine to make it really, really difficult to hire competitively. And you're pulling from an ever smaller pool the more identity categories you add to the mix. So all of that to say, they've been doing that for years, struggling with it. And even worse, even if you do find the magical unicorn that you're looking for that meets all of those as many of those characteristics as possible, that person comes and starts to work at your organization, and suddenly everyone wants them to be on every committee imaginable because their voice is so valuable. And so now they're overworked, they're underpaid, living in a state they don't want to live in a city they don't want to live in, and you lose them.
Well, and most of the time, and you can help me with this, Matthew, but I would say a lot of the time they're not going to. They could be. I'm not going to make the assumption they could bring different perspectives, but a lot of times they're going to just parrot what the other liberal person might say. Right? They're just doing it from a different suitcase over here. Right? They look different, saying the same things, and all of a sudden we get to count that as the real voice of diversity. The person that looks different has a different lifestyle over here that we've called white now, and they've said the same things. Yeah, but that's not diversity. And I'm like, they're saying the same things. It's
Right.
not diversity, except with the stuff they can't control, which is the way they look. So
yeah, if you did a blind audition and you couldn't hear like dialect or accent or whatever from where they might come from in the country, you couldn't tell the difference between a lot of the folks that get considered for these, because they do all. Yeah, there's massive ideological similarity, which we've talked about before. But yeah, so do I think that this decision will change the UT system and maybe even broader collegiate admissions processes? So my suspicion is that there are in fact a very small number of people who are responsible for writing these admissions policies that managed to get race conscious admissions in play. People that have the legal skill set to be able to write these policies so they don't immediately and obviously run afoul of legal precedent. The people who talk about holistic review, right, for admissions, that's these people. From what I've heard through the grapevine, they are confident that they can get around even this decision. They will just get even more clever about how they're writing things.
Those people should probably have written Biden's speech when he was talking about this. Those clever folks with the words. Don't you agree, Matthew? Because
it's all words. They think that they can solve any problem with words. Is the impression that I have, that the world is made through words,
perception and headlines. Yeah.
Right.
Yeah.
So I don't think ultimately they will actually succeed. I think people will see you're just using different words to describe the same thing. You're boring me.
Because it's not 70 or 80 years ago. This stuff is out. All of these topics we've talked about for 2 or 3 years are overlapping now because we've got all this influx of information and we can find things. The wool being pulled over our eyes, we can take it off real quick once we realize, oh, you're doing the same stuff. You just called it new fancy words and you've got a lab coat on or a doctorate degree on your wall. And so therefore I'm supposed to give it more credence. I'm not that, what is it? Dowlaw Josie Wells, don't piss down my leg and tell me it's raining or something. I know what's going on. Eric, to you about the Biden thing, I just want to say, one of the things that has popped up in my news feed a lot is the Titan owner, that the submersible that imploded, and it's a tragedy. But one of the things that came out that he had said is, I did not want to hire 50-year-old white guys with any military experience to captain the vessels because they weren't inspirational. And when I read that kind of stuff, I'm not saying 1 + 1 = 2. I'm just saying that's a bad mindset, I think, to go into something on any venture where you want to be successful. Don't you want the best voices and the best people, whether it's at school, flying planes, navigating your boats, or making your food? Eric, we
Yeah,
can talk about Biden
that's
saying that.
essentially what Clarence Thomas talks about in his concurrence in this opinion, and that has been a consistent argument, is that we should just who's the best person available, whether it's a man or woman, whether disabled, whether Native American, whether whatever race they are, who's the best person, who's the most qualified, let's go with them. And what Clarence Thomas basically says goes along with that, that it is maybe not yet true in society that that's always going to work out. It may not be always true. There may be institutions who have a bent to try to still institute affirmative action. There may be other institutions that have a bent to be selective in some other way. The men's club of the VFW might still prefer to hire men, or whatever it is. There's certain bents that you might have to go pay attention to. Who knows? But that overall, that we should be a merit-based system, and that the law, the Constitution, should be neutral and not allow for a thumb to be put on the scale for immutable characteristics like skin color that have nothing to do with whether the person can do the job or not. And Clarence Thomas's point is that's the way it's always should have been. We're finally living up to it, and if we leave it in that in place long enough, that's how things are eventually going to balance out. And if you keep trying to mess with the system by putting special rules in place, you keep messing that up, and it's going to make it worse longer.
I want you to talk about the Biden speech, but I want to ask you, I want to straw man. I don't know if straw man's the right word. I try to use words I don't know the meaning of. I'm going to dumb it down. I'm going to dumb it down for Clint. You ready? Here we go. I hear this quite often, especially from folks on the other side, that Clarence Thomas probably benefited from affirmative action, and there would be no Clarence Thomas really if affirmative, or may not have been, if affirmative action wasn't in place. Now, I disagree with that to some point, but he's addressed this, I think, several times. Eric, what's your thought on that before you want to talk about, I know Biden response is a big deal because it's one of the reasons we do our Tuesday deep dives. But what do you think about that, Clarence Thomas?
Let's answer that question first. Clarence Thomas was born in 1947, and he was raised in a southern town by his grandmother in poverty, and he managed to get admitted to a private, I think it was a Catholic school, through basically a program that they had to help poor people. And that's how he got a decent education. But he came up during a time when segregation was still in place in the 50s. And he basically says that America wasn't living up to his promise, but it eventually did. And that's an argument that he regularly makes. If you actually look at his life story, I would argue that he was not helped by overt affirmative action at any point. And that he did get through some tough times where racism was still going on, and he knows what it was like to be in a racist America. And the argument that he wouldn't be where he would be without affirmative action, I just don't think it cuts the mustard. And one of the big critiques is, he says one reason we need to end affirmative action is I'm tired as a Black American to be criticized for my achievements, because somebody can say, well, you got to where you were because of affirmative action. No, I got to where I was because of hard work and good grades and doing what I was required to do. And as long as there's affirmative action around, then there's always somebody who can be a bad actor, make a bad faith argument that, well, you got to where you were just because of affirmative action. And when the affirmative action is rampant, it's no longer a bad faith argument, because other people end up qualifying for their jobs absolutely because of affirmative action. One of the women on The View was just quoted as saying, well, I never would have gotten into Harvard if it wasn't for affirmative action. And now the right is running with that and saying, duh, and look where you ended up. You're one of those crazy people on The View. What's interesting is Ketanji Brown Jackson was born in 1970, after the civil rights era, in the same basically time period you are, and she's the one who's still adamantly arguing in the Supreme Court decision that we have a systemically racist nation with structural racism that needs to be basically perpetually addressed. How did she get her job?
Yeah. Biden
overtly the president of the United States said,
said,
I'm going to put up a woman of color.
just like vice president, that's how the
Yeah.
vice president was.
So-
And to I've heard Clarence Thomas talk about this a few times, and basically he was kind of saying what I've said in a clumsy way. It might have been at a point in time in American history we needed some immediate, like, we've got to stop the Jim Crow laws. We've got to put something in place. But at what point do you go? We're at a different society now. We have evolved past that, and now it can be more merit based. And so that's why I was asking. I kind of knew the answer. I just wanted to hear your take on it, sir.
Yep.
All
Now,
right.
before we run out of time,
Yeah, here we
we've been
go.
going for a little while. So President Biden was on on MSNBC last week, and here's part of the quote that he gave during his interview. The Constitution says, "We hold these truths to be self-evident. All men and women are created equal, endowed by their Creator." And then he kind of mumbled off. He said some other stuff, but I'm going to break this down one thing at a time. The Constitution does not say that, ladies and gentlemen. That's a quote from the Declaration of Independence, that all men are created equal and endowed by the Creator with certain inalienable rights, among those are life, liberty, and the pursuit of happiness. So that had to be prepared remarks. So whoever wrote that for him didn't even recognize there's a difference between the Constitution and the Bill of Rights. I mean, the Constitution and the Declaration of Independence. He also started mixing in, like, he's criticizing the affirmative action case, but he also starts mixing in Dobbs and in the abortion case, and he starts talking about the Supreme Court has given states powers that we fought a war over in 1860, as if the Civil War decided that the federal government somehow had plenary powers and could make all kinds of rules. I don't quite follow what he's saying. There's several other things he said, but one of the other parts here's the part that he said. Remember, the Federalist Society had a very, very strict construction of the Constitution. And if it didn't use the word, it didn't exist. But this administration, this court has gone beyond that. And I just find it, I don't know how to express it. I just find it sort of out of sorts with the basic value system of the American people. And I think that across the board, the vast majority of American people don't agree with a lot of decisions this court is making.
Wow.
All right, let's break this down on a couple different levels. If you are the Federalist Society, yeah, maybe is a society people said you should pay attention to the words that are in the Constitution, but isn't that what the whole point of a Constitution is? That's a debate we can have about how you interpret the Constitution. But criticizing the Federalist Society because they say these words in the Constitution matter, yeah, I think it kind of does matter. Now, when he's saying this administration, I think he's saying this current Supreme Court has gone beyond that. That's a pretty strong criticism of the institution of the Supreme Court. I would disagree. We could have a separate conversation about that. But that's something kind of interesting for the President of the United States to throw out, that the Supreme Court has gone beyond just closely interpreting the Constitution. I think it might be a fair criticism from his point of view to say that they are maybe interpreting it in a way that I would like them to be a little more looser on, but to say they're going beyond that doesn't make sense. They're out of sorts with the basic value system of the American people. Recent polling has shown that 75% of the population does not want race-based affirmative action. It's only 25%. Now, they're out of sorts with the people in Washington, D.C. that are surrounding the president, but they're not out of sorts with the American people. We can look at some of the old polling and see how that plays out over time. That'd be a good conversation for future topics. And then when he says things like the American people don't agree with a lot of the decisions the court are making, yeah, maybe some don't, but that doesn't. The point of the Supreme Court and our institutions is it's not a democratic institution.
Oh, it's not. I'm glad you said that. That's
We
what I
don't
was
get
going
to
to say.
vote on what the Supreme Court says. The whole point is they're interpreting the Constitution and federal laws, and they're supposed to stop us from doing things that are based on the tyranny of the majority. And so 2 points. I don't think he's right that the majority's disagreeing with all these things, and maybe there's a large segment of the population that's politically active on the progressive side that's pretty upset right now. I don't think the majority of the American people, but even if they are, so what?
Well, real quick,
the whole point of the Supreme Court is to enforce the Constitution and federal laws as they're written, not to follow the will of the majority.
There's a poll out right now. It's ABC News. 75% of Republicans approve the decision. 58% of independents approve the decision. And even 26% of Democrats approve the decision. So if you add it up, I think the total they came up with is over 50% approve. And I think there's like 16 to 18% that say they don't know and haven't made a decision yet. So to your point, when he says the majority of Americans, I think that's him being out of touch, not the court.
Yeah,
and
and
the
remember,
court's job's not to be in touch anyway.
it was just a few years ago that California, an extremely blue state, passed a law banning racial preferences in government hiring and in universities and stuff in California. So
Yeah.
I think that if people actually understand what's going on here, that picking and choosing winners and losers based on the color of their skin, and the result of that being that people of one skin color or one race, Asians, are excluded in higher numbers than they should be, that is classic racism. And doing that in a way to try to justify it, to give other people a leg up, you can't give somebody a plus if you're not giving someone else a minus if you only have a limited number of spots. And I think the more people understand that, the more they're going to understand how important decisions like this are. And then we go back to why I dropped the F-bomb earlier on. The media telling a different story is pretty darn frustrating.
Matthew, we're going to give it to you. Wrap it up, you and Eric.
You know, the public opinion polling on this is at least it appears tricky, but ultimately I don't think it is. When the pollsters ask, do you support affirmative action, you'll see that the kind of the split that you just referred to, Eric, in terms of how this Supreme Court decision was responded to. Right, Democrats will support it, Republicans will oppose it, independents will be kind of middling. But when you replace the euphemism that the word or the phrase affirmative action is with what affirmative action does, right? Race conscious or race based admissions, all of a sudden there's a lot more agreement. You don't see that split anymore. There was a Pew Research poll that was done where they did specifically ask whether or not race or ethnicity should be a factor in admissions decisions. And they asked whether it should be a major, a minor, or not even a factor at all. And Democrats opposed using race, saying that it should not be a factor, 63 to 36 against versus 4. So even Democrats and every single racial group that they included, whites, blacks, Hispanics, Asians, also, again, majorities opposing it. Overall, adults opposed it 73 to 26%. And none of the groups answered that it should be a major factor, above 18% of that group. So this is not something about which I think the American public is really actually all that much in disagreement over when you actually ask them what the most precise question.
No, they're not. Here's the deal, though. But they are against it if the microphone's stuck in their face by liberal media and go, "Hey, are you, are you for or against the Supreme Court removing constitutional rights?" Well, I'm against it.
Right.
There you go. Back to you in the studio. 100% of the people out here are not against, are not for the Constitution removing rights for American citizens. And you're like, wow.
So
man.
can I mention the opposite of that? Have you guys seen, there's a video going around, John Stossel, who is a libertarian, used to be on Fox News, goes to a New York shopping center, and he has a folding table set up, and he has a bunch of cupcakes. He has a sign up that says affirmative action bake sale. Cupcakes $1.50 for Asians, $1 for whites, and 50 cents for blacks. And he ends up doing street interviews, and a lot of the black people are the ones that walk up like, "What the hell? What are you doing? We can afford $1 for a cupcake, and why are you demeaning us like this?"
I'm different. I would want to identify a different way, so I can get 9 cupcakes for cheaper money. I'm like, I'm taking them. What the hell?
So check out that video. That's a good kind of play with the rest of this. My quick wrap up to this is, I was struck in law school when these cases earlier on, there were still some cases permitting, race as a plus and how you interpret that. And it has always bothered me that if you're going to use race as a factor in our society today with all the mixed race people, at what point are you, and this was, seriously copying the racial misogyny laws of a totalitarian country like Nazi Germany. And so to the extent that there are people that keep pushing for these racial preferences, they're doing it for large swaths of people based on broad classifications, and the Supreme Court has rejected that and says, no, you have to look at the individuals. Very, very last thing is I want to mention what the Supreme Court did say. How could race still be used as a factor? And the answer is sort of, if an individual wants to put in their college essay how race affected their life, then that can be considered, the Supreme Court said. And I
And
think
how they overcame it. That's
and
the
how
big
they
yeah.
how they overcame it, or how it affected, why that would add to their why they should be admitted to this university. And I think the point is the Supreme Court in the majority has clearly said that's part of the individual evaluation of each person. We're going to look at each person and their history, and that's fine. That's fine for universities to do that.
Okay.
But to give a blanket leg up based on the color of your skin, that is not what our colorblind constitution is not going to permit that.
All right. Matthew, did you want to add something? You look like you wanted to say something real quick. If not, I was going to make sure we wrap it up. But Matthew, go for it.
Real quick. I mean, that's
Yeah,
the piece that that a lot of these folks who write these affirmative action policies, I think, will try to use to retain the race-based admissions process. The thing that really is going to be difficult for them are, of those four criteria, the second and the fourth, which is it has to be measurable and it has to be achieving, it has to have an end in sight, which presumably is achievable. So at best, in order to meet those two requirements, whoever writes these new versions of affirmative action policies is going to have to do it in a way that is time limited, and very precise and measurable, which may work against the very assumptions that they want to work from. So I hope they have a really hard time with it.
I do too. Hope they fail. I know, Eric. Did you just check your phone, Eric Buchanan?
You're did, welcome. And it's actually, it should be, we have flints to pop, not caps to pop.
Okay, I'm sorry.
Just for the record.
I sent Matthew the same one. Enjoy. Hey, we usually been last couple of weeks been wrapping this up with recommendations and everything. I have one. Eric, do you have a recommendation or something?
Go ahead and do yours, and let me get mine out. I have one.
So mine is real simple. I want to recommend everybody go to Google and just do a search around bonus holes. That's all I want. I want everybody to go understand the crazy politically correct world we live in now, how it's changing things. It is bat crap crazy. I don't know how people think it's not offensive to people that are just sane. Just go down the rabbit hole of bonus holes, ladies and gentlemen. I think that'll be a pretty scary yet fun and creepy deep dive. Who wants to go next with their recommendation?
I don't know if I want to follow that, but I'll do it very quickly. So I have two recommendations. One is for tomorrow, July 4th. One of the things that I have sort of started pushing as a family tradition. We did it when we were to my mom's house last night and she had a few friends over, and she put American flags on the table and red, white, blue beads. And we had a pre-4th of July party with some of the people her age. And I read part of the Declaration of Independence. And when you actually read it out loud, especially the first few paragraphs, it's kind of meaningful to really think about what the founding fathers were going through. So recommendation number one, go read the Declaration of Independence. And if you have any kind of a get together tomorrow, the 4th of July, maybe read some of it out loud. The other one is a kind of a fun reading, go back and catch up on an old good book. My recommendation, Starship Troopers by Robert Heinlein. One of my favorite books. The movie absolutely blew freaking whale snot. That was one of the worst movies ever. And it totally basically didn't follow the original book. There was totally different technology in the book that made those soldiers special. But what else is interesting, in addition to Starship Troopers being a really good kind of a war story, coming of age story, it also overlays the discussions of politics in the future, and what it means to be a citizen and what it should mean to be a citizen. And I think it's a really great way to have a fun read over the summer, but also to learn a little bit about the thinking of what it means to contribute to society.
Matthew, your turn, buddy.
I have for those of you that are interested in learning more about homesteading, if you want a very easy entry into that world, there's a YouTube channel called the Holler Homestead, HOLLAR. It's a family who moved from suburban California to North Carolina several years ago, bought some land, and it's kind of just a slice of life channel where you get to see what they're doing. You get to learn what they're learning as they're learning it. They never make you feel, dumb. They do dumb things, and you get to kind of learn from their
They don't
mistakes.
make you feel dumb. Trying to do those tasks that the life will make you feel
Yes.
dumb. Yeah, as you
Absolutely.
succeed and fail in that, right?
It's just a family trying and learning things and doing projects, and it's very, very enjoyable. Great introduction for anyone who's interested in homesteading. Holler Homestead. Check them
There
out.
we go. Eric, we're doing a special July 4th tomorrow, right?
Absolutely. At normal time. Is that okay? 10:30?
Yeah, 10:30. I'll figure it out. Do we know the topic yet, or are we just going to wing it tomorrow? Or are we going to talk about that offline?
Declaration of Independence, the Founding Fathers, the 4th of July, maybe a little bit of Independence Day trivia. We'll have a good little show.
I'll be dressed accordingly. Hey, I'm going to end this the same way we started it. Are you ready to end it, boys? Have fun at work tomorrow, England. Bye, everybody.
See you guys. Good
Yeah.
show.